Hello, my name is Brittany Stapleton, and today I'll be discussing digital intellectual property and how it applies in modern computing, particularly in the context of software, online business, and AI-generated content. In Chapter 4 of A Gift of Fire, Basse introduces the concept of intellectual property as non-physical creation that can be owned. These include computer programs, digital media, inventions, trade secrets, and copyright works. As technology advances, the boundaries of intellectual property are becoming more complex, especially in digital environments where copying and distributing are effortless. Today, I will explain how intellectual property is classified and examine some modern ethical challenges related to digital ownership. So what is intellectual property? Well, Chapter 4, it explains that intellectual property, it protects creations of the mind. Unlike physical property, digital property can be copied infinitely at almost no cost. Basse outlines four main categories in this chapter, which is copyright, patent, trade secrets, and trademark. In digital computing, copyright and trade secrets are especially common, while patents apply to inventions and certain software-related innovations. The key issue is balancing two goals: encouraging innovation, allowing public access to knowledge, and these tensions drive many ethical debates in technology. So, copyright in digital content. Copyright protects creative works such as music, videos, books, software code, digital, and artwork. According to Chapter 4, copyright protects the expression of ideas, not the ideas themselves. For example, computer code is protected by copyright because it is an original written expression. However, digital copying is extremely easy. Basse discusses how file sharing, streaming, and digital duplications complicate enforcements. An ethical issue arises when people justify piracy by saying digital goods aren't real property, because copying doesn't remove the original. But Chapter 4 argues that creators deserve compensation. So copying does not physically deprive them of a product. Now, patents and software. Patents protect inventions and processes. In computing, patents may cover algorithms, hardware innovations, certain software processes. However, some patents are controversial. Basse discusses how overly broad patents can stifle innovation rather than encourage it. If companies patent fundamental algorithms, competitors may be prevented from building improvements. There are tensions between rewarding innovation and restricting technological progress. For example, if a company patents a basic AI optimization process, does that promote invention or limit competition? The trade secrets in digital business. Trade secrets protect confidential business information. Examples include proprietary algorithms like search engines, ranking formulas, recommendation systems, customer data, analytics strategies, business formulas. Unlike patents, trade secrets are not publicly disclosed. Chapter 4 explains that trade secrets can last indefinitely as long as secrecy is maintained. This raises ethical concerns when trade secrets affect public interest. For example, when algorithmic decisions influence hiring, lending, or healthcare but remain opaque. Transparency versus competitive protection becomes a key debate. So, the modern ethical challenge: AI-generated content. A new issue that connects strongly to Chapter 4 is AI-generated content. Questions arise such as who owns AI-generated artwork? Is AI training on copyright data a violation? Can AI-generated code be copyrighted? Chapter 4 emphasizes originality and authorship in copyright law. But AI blurs these boundaries. If a model is trained on millions of copyrighted works, is the output derivative? This demonstrates how digital intellectual property law struggles to adapt to new technology. So, the ethical balance. Chapter 4 repeatedly returns to the idea that intellectual property laws must balance incentives for creators, access for society. If protection is too weak, creators lose motivation. If protection is too strong, innovation slows and public access suffers. In digital environments where distribution costs are near zero, this balance becomes even more delicate. As computing professionals, we must understand not only the legal classifications, but the ethical implications of restricting or sharing digital content. So in conclusion, Chapter 4 of A Gift of Fire, it shows that intellectual property in the digital age is complex and evolving. Copyright protects creative expression. Patents protect inventions. Trade secrets protect confidential processes. However, in computing, where copying is easy and innovation builds rapidly on prior work, intellectual property law must carefully balance innovation and access. As future computing professionals, we must think critically about how ownership, transparency, and fairness intersect in digital systems. And that is my presentation on Chapter 4. This is Module 5, and again, my name is Brittany Stapleton. Thank you.